Hey everybody, welcome to this month's LinkedIn Live. Thanks to everybody for signing up and clicking that button to attend and for sharing it amongst your networks. Super excited to do this month's LinkedIn Live. Normally when we do these LinkedIn Live events and our OIG roundtables, we spend a lot of time talking to the SIU, the payer community, and we talk a lot about law enforcement related things. Here we're taking a little bit of a side path. We're going to talk about what really is a very, very important case. For those of you that are in the coding and auditing space, you may not be familiar with this, but for those of you who are practicing attorneys, either criminal, civil, regulatory, or the like, this is going to be something that you probably are familiar with, and it's the case of U.S. versus Dr. Richard Paulus. And I've brought on two great lawyers who I worked with very extensively on this case through a number of years that this case was going on. First is Hillary LoCicero, and I'm going to have you introduce yourself in a minute, and the other one is Stephen Lee. These are two really great people who knew this case from its inception and worked on the multiple trials, the multiple appeals, and the multiple legal challenges that went on. So, Hillary, I want to start with you. If you can just quickly introduce yourself, like where are you from, what do you do, and talk about your firm for a moment.
Absolutely. Thanks so much, Eric. I'm glad to be here. I'm Hillary LoCicero. I'm a partner in a small boutique law firm in Washington, D.C., BLL, LLP. I've been practicing in the white collar space for the last 15, 16 years here in Washington. I do have a focus on healthcare fraud in particular, although our small firm handles many types of white collar matters and complex civil litigation when it frequently goes hand in hand with white collar matters. As I said, thanks again for having me.
Great. And I will say, as a side thing, when I first met you, you were working with Bob Bennett, who is a great guy. I got to meet him. For those of you that don't know, he represented former President Bill Clinton a number of years ago on a number of issues that involved his impeachment and related matters. And it was really an honor to meet him because he really is someone who is a legend. He has since passed away, but he was a practicing attorney for a longer period of time than most people have been alive, and has probably had forgotten more about the law than many know. And for me, it was a really special time to be able to meet him and see him when I was working on the case on the sentencing phase, just to see him in the courtroom, and his mind was just unbelievably sharp. And so it was special for me to be able to meet him in that capacity, and I'm sure for you, having been mentored and trained in part by him. So it was a great opportunity. Stephen, what say you?
Yeah, so again, thanks for having us here. Really happy to be here talking about this case. Hi, everyone. My name's Stephen Lee, and I was an assistant U.S. attorney in Chicago for 11 years, and I served there as the senior counsel to the Chicago office's healthcare fraud unit. And it was in doing that I developed a very big practice using data analytics to make my cases back when I was a prosecutor, something I've talked about a lot. And I've been now in private practice for about 5 years, the last 2 of which as a solo practitioner. And I wasn't involved in the earlier stage of this case, but Hillary brought me on about 1.5 years ago to get ready for the second trial. There were a lot of data issues that came up, and that was how I initially got involved. But my role kind of expanded as things went on, and very happy to be here talking to you about the case.
And I will say, Stephen, the one thing that I was super impressed, outside of the fact that you understand healthcare fraud from the prosecutorial side and the implications of that, the one thing that I was super impressed about was your unbelievable understanding of data as a prosecutor. Most prosecutors do not have that kind of breadth of data understanding. But more importantly, you didn't just understand data, but your ability to play, manipulate, and manage the data was something that is way beyond what most prosecutors do. So it was pretty amazing just to see how you were able to massage and understand the way that the data worked in this case. So we've got a PowerPoint presentation that we're going to add into this. We've got probably we're going to be spending close to an hour talking about this case because it really was an important case. There were a lot of issues, constitutional issues. This case went up through to the Court of Appeals. There were a lot of issues at sentencing. So we're going to talk about the history of the case. We're going to talk about, how is it that what ultimately was a civil dispute became a criminal matter? And there's a lot of issues that come out with that. And in particularly when we're talking about some things, and I don't want to spend too much time on some of the legal implications, but when you're talking about, like, for example, on the False Claims Act, there's a lot of new case law about subjective subjective understanding versus objective understanding, and kind of in the criminal perspective, the mens rea, what was the individual's mindset at the time that they did something, and did that rise to the level of criminality? We're going to talk about the fact that this really was an unbelievable battle of competing expert opinions, something you rarely see. And Stephen and I have spoken a lot about the fact that competing expert opinions make really bad criminal cases, because how do you get a jury to weigh in on one opinion versus another when you're talking about 12 people who didn't get out of jury duty, and now you're asking them to make some definitive understanding, or in their mind be able to rationalize an expert's opinion. So we're going to talk about that. We're going to talk about a key component, which is cherry picking of data, and how when you cherry pick data, that is going to skew what the outcomes are going to be, and that is also going to skew what people's opinions are. And that's going to be relative to even talking about peer studies. And then the last thing that we're going to talk about is going to be billing data, paid versus billed. And for those of you that tune in to the OIG podcasts, we just did one last week where we talked about the U.S. sentencing guidelines and the fact that at least in the Third Circuit, and we're hoping that in other circuits that starts to become the prevailing thing, is that bill data is now become passé, at least in the Third Circuit, because everybody knows that billed amounts are hypothetical and made up numbers, and that we really should be going on paid amounts generally, regardless of the commentary that the U.S. sentencing guidelines have. So let me share my screen, and let's get right into this. So Hillary, let's start, and let's talk about
Sure.
Let's talk about this and see where we go.
Right. So this case started in 2008. At that time, somebody called an anonymous HHS hotline and left a complaint. Unbeknownst to my client, Dr. Paulus, HHS went on to do a probe sample, did a peer comparison, as they frequently do in these types of cases, and decided to refer the case for prosecution. Dr. Paulus didn't know anything about this until several years later. So in 2014, things were a little different. By that time, a civil subpoena had been served on the hospital where Dr. Paulus worked. They were in the midst of producing documents and negotiating a settlement for the hospital that related to a whole host of issues surrounding the False Claims Act. Around that time, someone, again, made an anonymous call, this time to the medical board in the state, and informed the medical board of the criminal investigation that was already going on. Dr. Paulus at that time had already retired. He hadn't practiced for over a year, and he simply said, I'm going to give up my license because I can see the writing on the wall here. I will probably be indicted. And that's exactly what happened. In 2015, he was indicted, and it took about a year and a half. In the latter part of 2016, he went to trial. And 7-week trial, as Eric mentioned in his opening, this was really a battle of the experts. There were days upon days of expert witness testimony from people hired by the government and by Dr. Paulus to present their opinions about the subjective judgments he had made in his medical practice. Unfortunately, Dr. Paulus, after 2 separate Allen charges and 5 days of deliberations and a very torn jury, they ultimately did convict him on some of the counts and acquitted him on some. But in a very unusual turn of events, the district court judge who oversaw the trial granted our Rule 29 motion for a judgment of acquittal. He said that no rational juror could have found guilt in this case, because really all the government had proved was that experts disagree about how to interpret these complicated medical images. We took the government got permission to take the case up to the Sixth Circuit, and the Sixth Circuit reinstated the conviction. In their opinion, if there are 2 sets of competing expert opinions, some experts vouching for the doctor's judgments and some disagreeing, then it's in the jury's hands. And a jury can decide which expert they believe is more credible. And if they believe the government's expert, then that's enough to support a guilty verdict. Dr. Paulus.
I'm sorry, and the one piece that I'll add is, where Advize came in is that we assisted with doing some of the calculations on the government's loss amounts. We
Right.
had There were kind of two competing pieces of this. The one piece was that, so Dr. Paulus, for those that don't know, is an interventional cardiologist, which means that he does angioplasties and he does stents. That's mostly what his day is comprised of. And for those of you that know this space, you know that for the most part, by the time the interventional cardiologist sees you, it is typically the day that you're on the table in the cath lab or the day before when it gets scheduled. And so, in this case, the U.S. Attorney's Office took a very broad position on loss amounts, and they did two things. One, they held Dr. Paulus accountable for the fully billed DRG. DRG is diagnostic related group, meaning that the entirety of the stay of the patient in the hospital, they attributed the entirety of that billed amount to Dr. Paulus. Whether he saw the patient on day one or didn't see the patient until day 30, he was being held accountable. And if you watched our U.S. Sentencing Guideline podcast from last week, we talked about the fraud table and the calculations of loss, that the guidelines have some language in there relative to what they call intended loss. And so we had two different angles, right? Hillary, we had the first angle was to have an expert in DRG pricing come in and look at what dollars are actually attributable to Dr. Paulus, because there are a whole host of things that go on for days or weeks or whatever that time period is before Dr. Paulus even sees the patient. And the one example that I always love to give was the patient who had, he passed out in his backyard doing lawn work or at his pool or something, gets a 911 call, goes to the hospital via ambulance, goes to the hospital, is an inpatient in the hospital for a period of time, having nothing to do with Dr. Paulus, has a bunch of tests and a bunch of things that are going on, diagnostic tests that have nothing to do with Dr. Paulus. Dr. Paulus sees the patient, conducts an angiogram, does a stent. The patient goes home the next day. For the first chunk of time that that patient was in the hospital, they had no idea who Dr. Paulus was. Dr. Paulus had no idea who the patient was, but yet the U.S. Attorney's Office attributed day one to the last day to Dr. Paulus. So we had, on the Advize side, we had an expert go and look at each one of those bills, the UB04s, and identify what was attributable to Dr. Paulus from a dollar amount on both billed and paid. And then I stepped in and thought that, trying to hold somebody accountable for the fully burdened billed amount was, in plain English, nonsense. And so, that was a huge piece of the factor. And I think, at the end of the day, Dr. Paulus was looking at a sentence that was substantially higher than that 5-year period of imprisonment. And so I think, from our perspective, we like to say that, what we did in furtherance of that in our testimony, and certainly your advocacy, certainly helped with getting the judge to understand that these billed amounts are really made up out of the ether.
Absolutely. The government was seeking a sentence of 10 years. So we were able to achieve, through the guidance and the testimony from Advize and through our advocacy, a 50% reduction in the sentence. And I would just say quickly, this is something that lawyers, even those of us who are well-versed in healthcare, really cannot do without consultants like Advize, because DRG groups and the way things are bundled become incredibly complicated. And we had to have an expert, or we just would not have been able to do it. So even though I think from a lawyer's perspective, we did get a really good, if you can call it that, result at the sentencing, we ended up filing a motion for a new trial because we had a really shocking revelation after the trial was over. And that was that information about the government's cherry picking of the procedures it had presented started to trickle out. What we found out was that during the time frame when the government was investigating, the hospital had done its own audit. And while we had always been told that the audit results were bad, in fact, the hospital had written a letter to the government and said, we reviewed over 1,000 of these procedures and we've identified 75, and we're going to make a payment, reverse under the False Claims Act, and refund that money. So obviously, the fact that 75 were marked was not a completely exculpatory factor, but the government had been telling us and had argued in the first trial at length that, and during the first appeal, that as much as 50% of Dr. Paulus's procedures were improper. So when we saw that very small 75 out of over 1,000, that's about 7%. We brought that to the appellate court. Dr. Paulus was incarcerated at that time, and the Sixth Circuit immediately ruled on the appeal as quickly as they could, and he was released after 9 months. Then, of course, we hoped we wouldn't have to have a second trial, given how complicated things had been, and we'd already been to the Sixth Circuit twice, but the government did, in fact, elect to move on to a second trial. Before that, we found out even more about the cherry picking, and we'll say some more about that later.
Yeah, that to me was an amazing revelation, because, you know, in the world of corporate integrity agreements on the civil side, you know, prior to some recent changes in corporate integrity agreements, anything that was under 5% wasn't even considered reportable under a corporate integrity agreement. Now, I didn't mean that you didn't have to pay the money back. If you look at corporate integrity agreements now, any overpayment that's identified is reportable, which is consistent with the Affordable Care Act and all of those things. So, but you're talking about a 7% error rate out of over 1,000 records. You're talking about, like, you know, from a mens rea and an intent perspective, how do you have, you know, such a small number? So, so Stephen, I want to go to you, because now we're at the, you know, you're putting on your criminal prosecutor hat, and now it's time to have a discussion about this objective intent, and then what I kind of alluded to, which is this subjectivity piece of what the provider thought in their heads at the time. So let's talk a little about that, Stephen.
Yeah, so this goes to one of the big issues that distinguishes healthcare fraud cases from other types of investigations, or, you know, both criminally and administratively. And that's really like this idea that, like, what makes a case a civil case versus a criminal case? And this goes to kind of where the government's coming from. Now, a lot of these cases around the country are handled civilly. In fact, as this was cases arguably part of this wave of cases the government was doing about 10, 15 years ago. And the vast majority of those cases were civil cases, which resulted in, you know, False Claims Act settlements. And the hospital in this case actually did, as Hillary was referring to, they did work out a False Claims Act settlement with the government. But the False Claims Act, it's a civil statute, and the issues there are very different. There, the standard proof is lower, is not beyond a reasonable doubt, and the intent element is very different. Because in False Claims Act cases, basically recklessness, should have known better, is generally good enough to get a False Claims Act case done. Now, criminal cases are very different. There we're dealing with beyond a reasonable doubt, and there we are dealing with actual knowledge and an actual intent. Because what was this individual person doing? So there, it's not enough for the government to say that Dr. Paulus should have known better, or that Dr. Paulus, you know, this isn't a, you know, he shouldn't have done this procedure. They have to prove that he actually knew that the procedure he was doing was improper and that it was breaking the law to do it. And that's a really big distinction. And that's why, to be honest, most of the cases that involve battle of the experts are resolved civilly, because it's really hard in those situations to say that's a criminal case. Now, and the big thing here there, so I think for any practitioner in this field, the big idea here is to really think about willfulness, because that's the concept that's in the statute, and that's really the big thing that distinguishes a criminal case from a civil case. And that here on the screen, you'll see the jury instruction that was used in the first trial and in the second trial. And it's really important here, I think, for everyone to keep this in mind, because there is some dispute and debate around the country about what willfulness means. And it is very important wherever you are to actually make sure you're using the right definition. I've had to fight this out on some of my other cases, because there I've seen government prosecutors using an incorrect definition of willfulness. So here, this definition is really important, and this is really the key thing. Now, the big thing here is, how does the government show willfulness, right? And so what happens in a lot of cases around the country, and what the government tried to do in this case, is to try to use something more to show it's not just a difference of opinion, to try to put in some extra things to show it's really, no, there really is willfulness. And that was a big part of the fight in this case. Now, I will say there are some things that I think generally are considered very strong evidence of willfulness. So, for example, if a provider starts to get investigated and they get a subpoena for like 10 patient files, and then they basically go into the patient files and create a lot of fake files and create new ones and destroy ones and basically get their staff to do it. Okay, well, that's generally pretty strong evidence of willfulness, because a provider wouldn't be doing those kinds of things unless they knew that what they were doing was illegal. I think that this case, I think the government thought they had this extra evidence to show willfulness, but I think over the course, especially over the course of the second trial, we really pushed back on that. And I think ultimately the government didn't have that kind of evidence. They'd like to think they maybe thought they did, but I don't think they did.
Yeah,
again, this comes back to the battle of the experts, which I think really was the core of the case. I think Hillary's going to talk about next.
Right, and that's an important piece of the puzzle. Is this battle of the experts, generally speaking, creates a whole host of issues when you're thinking about things in terms of prosecuting something with criminality. Because if you don't have two experts who can agree on something, then it's clearly a decision of who do you believe. And as most people understand, medicine is sometimes art, sometimes science, and being able to identify where the science and the art are separate is sometimes that challenge. So Hillary, let's talk a little bit about that, because when you've got these differing opinions, that creates a potential of there being doubt, or there being the inability for a jury to even understand what is going on. I mean, you put it into layman's terms, you go to your doctor and your doctor tells you have some medical anomaly or malfeasance that needs to be corrected. Most patients will go and get a second opinion, right? This is in that same vein, right? Differing opinions are going to be common in the medical field.
Absolutely. As we talked about a minute ago, Dr. Paulus was an interventional cardiologist. And in that role, his primary function was to interpret medical images called angiograms. And that's what you're seeing here on the screen. There is a general consensus in the medical community, although definitely not a hard and fast rule, but generally that when someone's coronary artery is blocked about 70% of the way, that's when a stent is useful and appropriate. Now, one thing we learned right away when getting into this case is that these rules have changed a great deal over the last 10 to 15 years, and that became important in the case as well. But the second thing we learned that was crucial was that doctors disagree. You can give an angiogram to 10 doctors and they are not going to give you the same answer. You may get 10 different answers. When the government presented their case at trial, they told the jury, by the time this trial's over, you're going to know how to interpret these, and it's going to be so obvious to you that this man was treating people whose arteries were perfectly healthy. And the picture you're seeing on the screen now is what the government showed in its opening and repeatedly through its case in chief as what they said a blockage should look like. This is what Dr. Paulus should have seen, and it's what you ought to see here in this courtroom if in fact this patient needed a stent. So our first job as his attorneys was to learn everything we could about this process of interpreting and evaluating angiograms. And although this is, of course, specific to cardiology, there's undoubtedly differences of opinion and subjectivity in every medical practice. So with any client, I think the first thing to do is to really get a deep dive into their practice and start figuring out where is the subjectivity. So we can go to the next slide, and I'll give you some examples of how this played out. So the government had their experts go one by one through different procedures and explain why they thought the blockage wasn't severe enough. Well, an angiogram is like a movie, and it's made of hundreds and hundreds of images looking at the artery from all different angles around the person's body. Here, what you're seeing on your frame is on the left, an exhibit that the government introduced and showed to the jury for one particular patient. And they said, oh, look how mild this is. He couldn't have possibly believed. And when I say believed, in a criminal context, that means personally, subjectively believed. He could not have possibly believed that artery was severely enough blocked to need a stent. But when our expert testified, he explained, well, I looked at the same images, and among those hundreds of images, I don't think that one the government's expert chose really is the best one to see where the disease is. And he showed the one that's on your right. The right side is Dr. Paulus's exhibit. And sure, the differences are subtle, but we're talking about something that doctors spend 15 years learning how to do in medical practice. And the very subtle differences between the left and the right is the difference between an artery that perhaps should have only been treated with more medications and one where a stent was a reasonable choice. So we talked a little bit about cherry picking. The government, they reviewed hundreds upon hundreds upon hundreds of angiograms, and they only showed the jury the ones where they felt their expert could make a compelling case for why Dr. Paulus was wrong. And then we were able to bring an expert who would vouch for him and who agreed with him on all of the ones the government was challenging. So if we move here again to the next slide, we did this. It was the classic battle of the experts, Eric, as you said, but we also wanted the jury to understand, in addition to this happening in real time in the courtroom, there is scientific literature that bore out the same result. In fact, in this field of medicine, there's a term, inter-observer variability. It just means more than one person is looking, they're going to see different things. So we showed the jury some information from medical studies. This one in particular, you can see this was from 1976. This is when the technology of angiography was really at its forefront, coming to the general practice. And you can see just from your eyes skimming left to right, there was lots of instances in this study where one observer thought there was zero blockage. Let's look at line A. Observer 1 thought there was no blockage. Observer 2 and 3 thought it was about 50%, and observer 4 thought it was 90%. So we showed the jury, look, this isn't something the lawyers dreamed up. We've had literature for the last 50 years that said this. The government, not surprisingly, when cross-examining our expert, pointed out that this was a really old study and said, oh, well, surely in the 50 years that have gone by, people have figured out how to account for these differences, and it doesn't happen like that anymore. So it was important for us to rebut that. So what we did, and you'll see this on the next slide, is that we also introduced, I'll go back for a minute. This is the same information from this little chart that was taken directly from the manuscript. And then Stephen, who is terrific with graphics, he created this slide to give the jury a more potent visual of what this means. So Stephen put all the numbers on the left, and then on the right, there's a gradient from 0% blocked to 100% blocked. And the yellow boxes represent where other expert angiography doctors ended up. So you can see, well, look at line S for Sam. We go all the way from 0 to 95%. There's some people in the middle and what have you. So this is a really remarkable way to take what was a kind of dry manuscript and make it really impactful for the jurors. And when we did it at trial, I think we had it where, with the clicks of the mouse, we could have these lines emerging one by one so they could see these broad ranges of how much people were disagreeing. So then, as I was saying, we wanted to clear up any kind of claim that, oh, it doesn't happen like this anymore. So we had an article that was from 2021, extremely recent, where the same kind of work was being done. In here, 14 different angiographers, cardiologists, were given angiograms and asked to say if they thought there was 30% or less, which would be, very mild and doesn't need treatment. Was it 30 to 50, 50 to 60, and so on, or was it as much as 90 or more? And here, just as we had in the study from 1976, we had a really remarkable degree of inter-observer variability. So again, Stephen built this slide to show how differently things come out depending on the expert you select. In that study from 2021, observer number 1 looked at all the angiograms, and there were only 12% of the time when he thought the blockage was 70% or more, meaning he probably would have stented. But let's take a look at expert number 7. He came to that conclusion 63% of the time. Now, of course, no one's ever alleged that reviewer 7 did anything wrong, and certainly not that observer 7 was committing a crime. But I would guess in all medical specialties, especially those that involve the interpretation of slides or images, there is going to be a spectrum along which people fall. And the fact that someone is like observer number 7 is not enough on its own to show criminality.
You know, and one important thing that I want everybody to understand is that the purpose of these charts is not to create an air of confusion for the jury. Oftentimes, my experience has been that oftentimes defense attorneys will do things to create that level of confusion to get at least one juror to think not guilty, to get a hung jury, because the government needs to get it right all the time and the defense only needs to get it right, you know, with one. But the importance here is to show that this is not just science, that this is a little bit of art, and that in this case, a number of experts were queried, and we'll talk about that in a minute, but empirical data suggests that there isn't even a consensus amongst a number of different observers looking at the exact same documents. They're coming up with entirely different conclusions. Ergo, it should be putting into someone's head as you're watching this question of intent. Meaning, if you don't have two people who are even in agreement about this, how can we say that the defendant in this case was inherently intent on defrauding? Because that's ultimately what this comes down to, is that the patient did not meet clinical criteria to warrant having the stent. This is not about the angiogram, right? This is not about putting the person on the table and doing the test. It's essentially about the upcoding to the stent, or the add-on of doing the stent. But what this is showing empirically is that there is such divergent information out there that two people in the exact same situation can have two very different opinions.
Right, and just like you said earlier, this is why patients are able to choose amongst a variety of doctors who they believe would treat them in the way that they prefer to be treated. There are patients who want more aggressive treatment. There are patients who want more conservative treatment. So after we had presented our expert testimony, we also showed the jury that among the people who they had heard live in the courtroom, inter-observer variability had come to life in front of them. And many times it was between the government's own experts. So we put together this slide to show, just as I was talking about before, on the left, the picture that the government's expert, Michael Regasta, chose. In the middle, we have a slide that was chosen by another cardiologist at Paulus's hospital. And in this procedure, he was the one who decided this person needed a stent. He found the blockage. You can see from the chart above, he thought this was a 90% blockage, and he called Dr. Paulus in just to do the mechanical process of placing the stent. Now, I'll say, especially for the lawyers who are listening, we felt fairly confident that given it was a different doctor who interpreted this angiogram and simply asked Paulus to come in, Paulus concurred with him and did the stent. I don't know how that is consistent with criminality. So here on this chart, we're seeing our expert was Joel Kahn. He's a wonderful interventional cardiologist in Detroit. He thought it was a 90%. Paulus's colleague thought it was a 90. Paulus himself had written in his charts he thought it was an 80. And it was the one government expert who thought it was a 35% blockage and that the stent wasn't needed.
And just to clarify for everyone, part of this is that this is the eye, the expertise, the training, the education, the knowledge. It's all of these things that are both science and art to determine if
Right.
something is 80% or 90%. A lot of that is going to be just based upon education and training. There isn't necessarily something where it's one thing to say 0 to 90. That's a very divergent, difference. But if we're talking about
Right.
80 to 90, somebody else might look at it and go, it could be 75. Somebody else might look at it and say it could be 85. So we really are talking about a difference of opinion based upon who it is that's looking at it at the moment, right?
Right. Yeah, absolutely. And we saw, I think, as this field has progressed over the last decades, people are becoming more limiting in when they believe stents are appropriate. The science is starting to bear that out. And we had to be very careful because we had a trial in 2023 talking about procedures that Dr. Paulus did in 2008. And so we had to be very careful not to allow the government's experts to try to attribute knowledge to Dr. Paulus that he could not possibly have had. For example, there was a lot of argument that he should have used a different kind of technology that uses a wire with a sensor on it to see how rapidly blood is flowing through a blockage. And I don't know how many times we had to remind the jury, this rural hospital in Kentucky did not have that technology in those years. So it's easy for the government to put people on the stand who criticize him for not using the pressure wire, but he didn't have it.
Right.
And that just goes to another interesting thing about these types of cases. The technology available to the doctor is not always the same. Are you in a rural hospital system or are you in a teaching hospital in a metropolitan area? That can make a big difference.
And the other piece, and then we're going to go over to Stephen to talk a little bit more, but the other piece of this is the fact that there isn't even a consensus within the payer community and the medical community about how much of an occlusion would require a stent, right? I mean, I've seen
Right.
things that talk about 70%. I've seen some articles that talked about as little as 50%. And so
Right.
there is a divergence even within the payer community. And then you throw in the added layer of the complexities of what is the technology at hand, right? So having the guide wire, which can measure flow, can probably give you a much more accurate assessment today in 2024 or 2023 regarding the percentage of occlusion. In 2008, it really does seem like it was much more art than science.
Absolutely. Absolutely. And this, it's a bigger point that Stephen will touch on as well, but jurors have been patients. All of us have been patients, but we like to think that everything that we hear from a doctor is ironclad. And the fact that medicine does involve art, we really had to trust our jurors that they would understand that and be able to give our client the benefit of the doubt. And I think the results showed that they were able to do that.
Right. So, Stephen, I want to go to your sweet spot for the next little bit that we're going to talk about, and towards the, kind of the wrap up here is the data and this whole premise of cherry picking and the importance of objectivity in your data analysis as it relates to both your charging document and your counts in how you're going to prove your case.
Yeah, and I think there are a lot of issues here with how the government chose to present the data and some of the mistakes I think they made along the way. And I think that one of the things that's probably very important for people to remember here is that the government did not use statistical sampling in building its criminal case. Now, the government's not obligated to use statistical sampling and do so, and they are allowed to do cherry picking, but it's got to be very clear that that's what they're doing, right? And because you can't extrapolate from cherry-picked examples. And so that's one of the big issues that we had to deal with in kind of giving the jury the broader context to understand that what they were seeing wasn't really representative of the overall practice. And that was a big issue that we had to deal with during trial. So, this slide, and actually, I think most of the slides that you've seen so far were part of the closing arguments or opening arguments. So this one, go back one, Eric. But this one represents the false statement counts. each one of these boxes represents one of the specific procedures where the government claimed that Dr. Paulus not just did something that, not just did something that was turned out to be unnecessary, but that Dr. Paulus actually lied in the patient charts about the degree of stenosis that he saw in the patient's arteries. So this was something where the jury actually had to decide, did Dr. Paulus lie in his patient charts? And one of the big things the government did, I think, is because these are false statement counts. But if you go to the next slide, what the government did was they put in lots of other angiograms, lots of other procedures. And the next slide kind of puts all of the procedures that the government had some expert testify about. So go one forward. OK, and so here it shows, I think, this one shows all the procedures that they put in. And the way they're grouped is actually by expert. So the first group is largely the ones at the top. That's largely one expert from the government, plus I think one or two others to help out. The other groupings are the experts who, group by expert. So then there's, so you can see kind of like they called multiple experts to testify multiple procedures. And they kind of did this whole thing where they kind of try to present all these times where Dr. Paulus got it wrong, according to this expert, and all these times that Dr. Paulus got it wrong, according to this other expert. But there was a lot of context missing from that. And actually, the first thing is if you go to the next slide, what the government didn't do is those are all independent judgments. The government didn't take these procedures and show them to 10 experts, and all 10 experts came back and said, oh, yeah, totally improper to do this, never would have done it. They didn't do that. They only did that. So there only were, of all the cases the government put in their case in chief, there were only 5 times where one expert said it was improper and another expert backed them up. And that was pretty important because that really does kind of undercut. It really is kind of hard to say then that Dr. Paulus did it wrong when it's really just, it's not his word against 10 other experts who disagree with him. It's his word against one other person, maybe 2. And especially as we showed through all this, there were actually lots of instances like the one that Hillary was talking about earlier, where another doctor at that hospital actually had recommended the procedure. So someone else had actually agreed with Dr. Paulus. So it really was kind of like the cumulative effect of this was not quite as powerful as I think the government tried to present in this case in chief. So that's one area, because just calling more experts didn't really change the fact it's still just one or two experts against Dr. Paulus. The second thing, you go to the next slide, is the next thing. Oh, maybe a little. OK. The next thing is, so one of the ways we try to deal with that is we actually try to put the data into more context. So one thing that we did in this case is, and I think that maybe is something that I think more people on the defense side should think about, is we actually requested additional data from the government because we wanted this additional data to put Dr. Paulus's practice into context, and we did our own analysis do that. This chart, for example, showed, because the government only put in instances in their case in chief about instances where Dr. Paulus did an angiogram or someone else, a few times when someone else did, and then Dr. Paulus did a stent. So we want to show, wait. But that's not the way it actually worked. Dr. Paulus did a lot of angiograms, and a lot of the times he did not do a stent, because that's really important. Because if Dr. Paulus had actually done a stent every single time he did an angiogram, well, to be honest, that would suggest more fraud, right? That would be more indicative of fraud. But that actually is not. But that's not what the data actually showed. So here, for example, and we just did this. We created a chart that went through every single stent procedure that got billed to Medicare and angiogram. And we saw, and the blue boxes here, if you look at these, a lot of these represent times when Dr. Paulus did a catheterization, but did not do a stent, or when he did a stent, but some other doctor had did the catheterization and had recommended the stent in the first place. And so this is one way that we try to put everything in context. I'll go to the next slide. Another thing that we did was we really tried to show kind of ultimately that the government hadn't just cherry-picked procedures, they cherry-picked their experts. So Hillary mentioned earlier on, there was a hospital review. There was a review done by the hospital. And what happened was, it's pretty complicated what happened, but basically the hospital had done a review, and the review had been done, and basically the government wanted to put in just all the results of the review without calling the actual experts who had actually done the review. And the judge agreed with us that this is a constitutional issue, and that Dr. Paulus had the right to confront his accusers. And if you want to use an expert's information against Dr. Paulus, the government has to call the expert so that Dr. Paulus has a chance to cross-examine him. And so the government ended up calling 2 experts, and they testified about, in the case, the government's case, and they testified about all the procedures that they believed were unnecessary, and that they thought that stent should have been done. But that was cherry picking, because if you go to the next slide, what turns out is that those 2 experts were just 2 of the experts who were involved. So there were about 20 cardiologists who were part of the cardiologist review, and basically the government, they had picked 2 of the doctors who disagreed the most with Dr. Paulus. But there's a spectrum, and not every doctor felt the same way. And so in our case in chief, go to the next slide, we subpoenaed and we called to testify a doctor. Oh, go back one. We called a doctor in the defense case who largely agreed with Dr. Paulus. And here you can see how it shakes out. And here's a slide that kind of puts them in context. The government's experts, yeah, they saw, well, first of all of these experts, even the ones the government's called, they actually agreed with Paulus most of the time. Now, the government now highlighted the 30% of the cases where the government's experts disagree with Dr. Paulus, but even there, they still agree with Dr. Paulus most of the time. But then the expert we called, he agreed with Dr. Paulus about 90% plus of the time. And so it really kind of shows this whole idea that, like, is it really that basically Dr. Paulus was really committing fraud, happened to commit fraud on the procedures that the 2 government's experts reviewed, but didn't commit fraud on the procedures that the defense expert reviewed? Or is it really just a lot of this really has to do with just who you happen to get as an expert, and different people come with different opinions. So a big part of the case really was trying to kind of like unpack and show that the government had been doing cherry picking, both in terms of the procedures and in terms of their experts. And so this larger context was a big part of the defense case, throughout the government's through crossing the government's witnesses and through the defense case we put on. The other big issue that we had to deal with was peer comparisons, and that gets to the next area. So this is something that played a huge part in the first trial, and that also played a role in the second trial. And this was also one of those things that I think one of the reasons why Hillary kind of, reached out and kind of got me involved in the case. So what happened here was the government made a big point of how Dr. Paulus was the top provider in his state and one of the top providers in the country. Well, which is true, but there's context. And the government, there was none of that context to show, how meaningful is that? And this is something that was interesting that came out. Hillary talked earlier about the review that was done by the Medicare contractor way back at the beginning. And that was important because back then they did a probe sample, and they had an expert who did review a few procedures and did disagree with Dr. Paulus on enough of them that the contractor thought it was noteworthy. They did a peer comparison and saw that Dr. Paulus was one of the top billers in the country in terms of Medicare. But what they didn't do is see, well, is how meaningful is that? Is that actually an indication of fraud, or is that explainable? And from our point of view, it was. Dr. Paulus was seeing patients in one of the sickest parts of the country for this type of heart disease, and he was at a hospital which specialized in this, and that was his practice. So to be honest, first of all, someone's got to be the number 1 provider in the state, and just because you're the number 1 provider in the state doesn't mean that you're automatically committing fraud. And given everything else, that ultimately the overall context, I think, showed that it really wasn't unexplainable. It wasn't that this is a situation where the data can only be explained by fraud. And this is one of the big things we did, because these were the numbers the government used. And we ended up actually took motions, but we eventually got additional data about the peers whom the government was trying to compare Dr. Paulus to. And that
And
data
Stephen, I
was
just want
really
to, if I
important.
just interrupt you real quick, but you know, and you made it as a point, but it resonated with me, the fact that Dr. Paulus was working in what has been considered one of the poorest communities in the country, with one of the highest incidences of cardiovascular disease. And so, kind of by default, he's going to be an outlier by the nature of where he is. And if you think about it in some contexts, if you're working as an orthopedic physician and you do knee replacement surgery, and you happen to do knee replacement surgery at the busiest joint replacement center in the state where you live, and you have a hospital that has a sole source contract with one of the device manufacturers, you're inherently going to be an outlier because of a bunch of other factors, right? And to me, it resonated very strongly, the fact that Dr. Paulus is an interventional cardiologist in a community that has one of the highest poverty rates, which means there isn't the accessibility to fruits, vegetables, good foods, right? It's fast food, it's high fat food, it's the things that make our hearts sick. And the fact that he was operating in that area, some would say, well, how is it that a guy working in a rural community and not a major metropolitan area, how is it that he winds up being the number 5 guy in the country? Well, there were a bunch of collateral factors that data doesn't explain, right? Because it's just numbers. And
Well,
I always argue numbers lie to you until you've proven either way that they're not lying to you.
I believe the data is extremely powerful, but you got to be careful, right? You got to be careful, and you got to do reality checks. You got to really dig to see, is the data really telling you something that actually is meaningful? And so this one, so here, the government tried to make a big point of the fact that Dr. Paulus is up there, but if you go to the next slide, you can see like, well, we put in context, right? And you can see here, well, yes, Dr. Paulus is doing a lot of CATs, and he is doing a lot of stents. But first of all, again, if you look here, he's the second up from the left. First of all, again, you're seeing he's doing, this is showing the number of patients, Medicare patients for whom he's doing a catheter or stent. And you can see, first of all, here's a way of showing he's not doing a stent on every single patient he has a cath for. In fact, he's doing, and his ratio is not that different from other top cardiologists in this field. So first of all, that's one sign that's really kind of against the idea of fraud. Again, if he was doing a stent for every single patient he did catheterization for, well, that might be something, but he wasn't. And if you go to the next slide, and again, this is another way of showing it. He's really not that, it's not that different. And first of all, and also, well, this one shows the same thing, but this one also shows there are a lot of patients he was seeing he didn't do a catheterization or a stent for. Now, the way the government presented its case, it made it sound like all Dr. Paulus did all the time was catheterization and stents. But that's missing a lot of the context because there were lots of patients he didn't do any of those procedures for whatsoever. And again, look, yeah, for a fraud case, it's really kind of cutting away. And so a big part of the case really was kind of putting this stuff into context, really showing that the peer comparison the government wanted to make really shouldn't lead to the conclusion the government wanted the jury to draw, which is that the only way it could be explained was fraud, because it wasn't. There were other explanations for what was going on. And let me come back to this, because this is actually kind of going back to the point about data and a larger point probably for everyone. Like, I think Eric and I, huge believers that data can really be powerful, but you got to be careful. You got to be careful. So what happened in the case, the government, after we put in this is one of the summary charts we put in, one of the things the government did on cross-examination is they highlighted one particular patient. And they point out that from the data showed that Dr. Paulus had done a stent on a patient who was in her 90s, and that her date of death was the very next day. Now, that was, I think, kind of a big moment in the trial, because it really kind of, I think it was kind of shocking to a lot of people. And basically, that was something that the government just left hanging out there, just based on the data. We then told the government the next day that we had the patient file, the government had the patient file, and that we were going to have an expert talk about what actually happened with that incident the very next day. The government objected, but the court said that he was going to let us get into that because he saw how the jury had reacted when the government had basically suggested that Dr. Paulus had done an unnecessary procedure that resulted in the patient's death. And then when we went through the whole file, Hillary took the expert through the whole file, and it showed that basically this was an extremely difficult situation. Multiple medical professionals had been involved in the care. Another doctor had recommended the procedure that Dr. Paulus did. Dr. Paulus was in at the hospital at about 1 or 2 a.m. on the Sunday before Christmas doing the procedure, and the procedure had gone well, and that the patient died from other conditions the next day. That's what the whole file showed. This is something, data is extremely powerful, but you got to make sure that the actual story is what is true. And that insinuation by the government really kind of, I think, actually kind of backfired on them because it was a pretty shocking moment, but it really opened the door for us to get in a lot of evidence, that useful evidence that otherwise wouldn't come in. And it became a big part, kind of part of the overall themes of the case in making sure, like, you really got to make sure, do you really believe what the government's saying? I think we're just nearing the end. I do want to come back to one thing that Erica said earlier, just to kind of round it out. We talked about billed amounts versus paid amounts. Huge issue around the country. I think medical professionals all know that the billed amounts they're just numbers that really don't have much to do with what actually gets paid. Now, that is a huge issue in the courts. It was actually a pretty big issue in this trial because the government a lot of times would emphasize the billed amounts without putting in the paid amounts. And so that was something we actually had to do throughout the course of the trial and really showing like, okay, yeah, but what was actually paid? Because it turned out actually the government put in lots of billed amounts. They didn't put in paid amounts. We ended up showing some of that to the jury, but the government actually didn't, which was a little odd. And I think but I think partially it's because so that's why those numbers can be very misleading. And again, they have to put it in a proper context.
Yeah. So Hillary, as we run out of time, and this was an absolutely amazing time to spend with the two of you and to educate people about this. What was the ultimate result? So Dr. Paulus has had a very long road, and obviously it resulted in a very lengthy second trial. What was the ultimate resolution to this trial? And I think you may be both on mute and off camera, so just double check that.
Sure. So after about 5 days of deliberations, the jury, despite an Allen charge, said, we've got a verdict on one count and we can't keep going on the other counts. So we were fortunate that Dr. Paulus was acquitted on one of the substantive counts against him. And we were not able to really discern why it was that count as opposed to the others. And it brings it back to an issue you mentioned earlier, Eric, which is at the end of the day, when you've got a case that's all about a battle of the experts, you end up with 12 lay people in a room. If they believe the government's premise of the case, which is decide the expert you think is right and go with them, you're asking people with no medical background to make really sensitive medical judgments. We were fortunate, though, that the jury really agreed that he was not guilty on one count and they were not going to convict him on anything. Having represented Dr. Paulus for 12 plus years, we went through a fairly agonizing month after that fact until the government announced they would not seek a third trial in this case. Bob Bennett and I spent more than a decade on this matter. It's through his exceptional lawyering and leadership that Dr. Paulus was able to make it through. And it was a privilege to do that and to bring it home along with Stephen.
Yeah, and just there are obviously a whole bunch of collateral, and this is really a slide deck that summarizes 10 plus years of effort into an hour. And obviously, part of this is that Dr. Paulus had some financial resources that allowed him to have strong legal representation that other people in this world may not have. And so we don't take that that's not taken lightly. right? You are a DC-based lawyer. Stephen is a Chicago-based lawyer, and there are factors that come into play collaterally on doing that. But this does show that there are instances when the government doesn't always get it right, and that differences of opinion and a hung jury clearly demonstrates that, right? That there are such a diverse number of opinions that were presented in this trial, and as a result, such a diverse number of opinions that the 12 jurors had as a result of this. So it was really a lot of up and downs, obviously for Dr. Paulus, for this, for you, because you lived it for so many years, and it was just seeing it and experiencing just the little piece that I had was a great experience for me. I don't take away the fact that it was a harrowing experience for Dr. Paulus on this, but it ultimately comes down to right is right and wrong is wrong. You've got to pick your battles properly, and I think what this really does demonstrate, at least in this case, is that and we didn't really get a chance to talk about this, but historically, cases that came to fruition that involved issues of medical necessity with stents were really dealt with in a civil context. And I remember when I was working with you on the first trial, that this was a unique case because of that, because Dr. Paulus had been put out as a criminal on this, when this was really something that was a difference of opinion and was civil. And in fact, the hospital where he worked addressed this from a civil context. So there's a ton that we could unpack. We could sit and spend probably hours more talking about this, because there was just so much information that came about on any case that's 10 years. We didn't even get into the fact that there were changes in AUSAs. I think there was even a change in the OIG agent. There's also issues when you talk about venue. We could go on and talk about, in different places of the country, U.S. attorneys' offices have different levels of expertise, and was doing a traditional healthcare fraud case within that level of expertise for this particular U.S. attorney's office. There's a whole bunch of different things. You see it all the time, right, with key tams. Whistleblower lawyers will file a key tam in a district where they have the greatest chance of having that case come to fruition. So, in this case, that wasn't really an option, right? We could always go into another whole conversation about the change of venue discussions. We didn't even get a chance to talk about that, but we could spend hours talking about this. For me personally, it was a very interesting case for me. Having worked on the government side for my career, and then having done this particular case, and I've worked on a lot of cases with the defense, this was one of those cases where I just didn't quite understand what the point was at the end of the day. And I think obviously for you, it was the same thing, is what's the point? So it was great to have you both on. I appreciate the friendship that I've been able to develop with the two of you. I appreciate the legal pieces of this puzzle, and the fact that this really was a very unique case from that perspective. So for those of you that have tuned into this month's LinkedIn Live, it obviously was a little bit longer. It deserved the time to be spent, because it did touch upon a bunch of different things. Again, thanks to everybody for tuning in to this month's LinkedIn Live. You can catch all of our previous LinkedIn Lives, all of our OIG roundtables on our YouTube channel, on our newsletter. Feel free to reach out to me, hello@advizehealth.com. As you saw on that last slide, Hillary and Stephen's information is there. We can provide that to you if you need in the future. I look forward to collaborating with you on more important and interesting cases in the future. Again, I look forward to having you on future LinkedIn Lives and broadcasts. We could talk about this stuff for hours on end. So thank you very much. I appreciate everybody spending their time, and tune in to our next LinkedIn Live next month. We're going to be talking about behavioral health, and we're going to be doing a whole bunch of stuff about audits in the behavioral health space and some of the implications from fraud, waste, and abuse and compliance. So thanks again for tuning in to this month's LinkedIn Live. And again, thanks to the both of you for being my guests.
Thanks so much, Eric.
Thanks, everyone.